Moving on now, the Commission on Human Rights and Administrative Justice, CHRAJ, says it has completed investigation into allegations of corruption in the implementation of Zoomlion's contracts with metropolitan, municipal and district assemblies. The sanitation improvements package is one of Zoomlion's contracts with all assemblies, and payments have been deducted and paid to Zoomlion for more than 10 years. In 2009, a whistleblower from the Tano South District of the Buno-Ahafo region petitioned CHRAJ alleging that Zoomlion was colluding with the assembly officials to defraud the state. Why did it take CHRAJ so long to investigate?
We got a whistleblower disclosure. I think it was in around 2014, to the effect that Zoomlion, the administrator of the Common Fund, and 138 district assemblies were colluding, conniving to defraud the state. And so we should investigate and make sure that the monies that were wrongfully paid are paid back to the state. So we began our investigations, but we were stopped by a court action. Zoomlion took the position that this is not a matter that the Commission has the jurisdiction to investigate. And so we had a tangle in the court. In the end, we were able to convince the court that Zoomlion got it all wrong. Their basis for challenging the jurisdiction of CHRAJ was that they are a private entity, and so the Commission can only investigate public officials in regard to corruption. And so once they are not a public company, or they are not public officials, we cannot investigate them. Of course, our position was that we can investigate them, even under the Act, because of the interpretation given to our mandate by the Supreme Court in the case of Baba Kamara and others. I don't know whether you remember that case, the Mabi and Johnson case, in which Baba Kamara then challenged the jurisdiction of the same commission in the same manner, and the Supreme Court interpreted Article 218 to be that, one, anytime the Commission is investigating public officials and private bodies, persons, entities are enmeshed in the allegations, the Commission should extend its investigation to cover those private bodies and entities. And so that ratio was applied in the High Court to determine that the Commission has the power to investigate Zoomlion, not only because they are a private entity and the Supreme Court could go ahead, has given the Commission the power to investigate, but that it is a whistleblower complaint. And all whistleblower disclosures, there is nothing about private person or public person. All persons, Ghanaian, natural or artificial companies, are liable to investigation by the Commission. So that was the upshot. But of course, there was some unnecessary delay in court. Since then, we have proceeded, and we have covered all the 138 at that time, the district assemblies that were then in existence in Ghana were 138. We have concluded. Our report is being compiled, and hopefully we would come out with our decision.
Expect more on this issue in our subsequent bulletins.